Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving exclusion clause, a key topic in contract law under FLK1. Let's dive in. Paul, who could not read Italian, traveled from London to Venice. On arrival, he stored his bag at the railway station's luggage counter. He was given a ticket which had a number on the front and a direction to see back. On the reverse side was a clause written in Italian excluding liability for loss or theft. A sign with similar wording, also in Italian, was displayed behind the counter. At the end of the day, Paul returned, only to be told that his bag had been stolen. Paul now asks whether he can claim against the counter, arguing that he could not read Italian and would not have stored his bag there had he known about the exclusion clause. What is the legal position under English law? Paul can claim because the clause was written in a foreign language he could not understand. B. Paul cannot claim because the exclusion clause was brought to his attention by reasonable notice. C. Paul can claim because he never signed a written contract accepting the terms. D. Paul cannot claim because such exclusion clauses are legally implied into luggage storage contracts. E. Paul can claim unless the counter staff specifically explained the clause to him in English. The best answer is B. Paul cannot claim because the exclusion clause was brought to his attention by reasonable notice. Under English law, an exclusion clause can be incorporated into a contract if reasonable steps were taken to bring it to the attention of the other party before or at the time the contract is made, even if the party did not actually read or understand it. In Paul's case, he was given a ticket that clearly stated "see back," which is a common method of alerting someone to terms on the reverse side. The clause on the back excluded liability and was supported by a sign with similar wording prominently displayed at the counter. Although the clause was written in Italian, Paul's inability to read the language does not invalidate incorporation, so long as reasonable notice was given. This principle was upheld in Thompson and LMS Railway, 1930, where a non-literate woman was still bound by an exclusion clause printed on a ticket, because the company had taken reasonable steps to notify her of it. Therefore, Paul's language difficulty does not release him from the contract, as the railway station did what was legally required. The law does not require the business to translate terms into every customer's native language. Scenario 2. Same initial fact that Paul went to Venice and received a ticket written in Italian. Paul asked the attendant for an English translation of the words on the ticket, indicating he could not read Italian. The counter staff refused to provide one. At the end of the day, Paul returned, only to be told that his bag had been stolen. Paul now asks whether he can claim against the counter. What is the legal position under English law? Paul can claim because the clause was in a language he could not understand and no translation was given. B. Paul cannot claim because exclusion clauses are valid, they are printed on the back of a ticket. C. Paul cannot claim because the exclusion clause was brought to his attention by reasonable notice. D. Paul can claim because the staff refused to take reasonable steps to bring the term to his understanding. E. Paul can claim only if the term was unusual or unexpected. The best answer is D. Paul can claim because the staff refused to take reasonable steps to bring the term to his understanding. Normally, under Thompson and LMS Railway, 1930, if reasonable notice is given, for example, a ticket saying "see back" and a sign, the clause may be incorporated even if the customer doesn't actually read it. However, in this specific scenario, the company had actual knowledge that the customer could not understand the notice and asked for help. This triggers a higher duty under the principle from Geyer and Kujawa, 1970. If the business is aware that a person cannot access or understand the information due to a disability or language barrier, then simply pointing to the ticket is not enough. They must take reasonable steps to explain or translate. By refusing Paul's request, the staff failed to take reasonable steps. Therefore, the exclusion clause was not validly incorporated, and Paul can claim for the loss of his bag. Scenario 3. Paul paid for a hotel room in advance at the reception desk. He checked in and received a key and went to his assigned room. Inside the room, he saw a notice on the wall stated, "The hotel will not hold itself responsible for any items lost or stolen unless handed to reception for safe custody." Paul left his iPhone on the bedside table. It was stolen while he was out. He now wants to claim compensation from the hotel. Can the hotel rely on the exclusion clause? A. No, because the clause was communicated only after the contract was formed. B. Yes, because the clause was written in clear English and prominently displayed in the room. C. No, because exclusion clauses for theft are automatically invalid in hotel contracts. D. Yes, because the clause is reasonable under the Consumer Rights Act 2015. E. No, unless Paul signed a document expressly accepting the term. The best answer is A. No, because the clause was communicated only after the contract was formed. Under English law, for an exclusion clause to be enforceable, it must be incorporated into the contract at or before the time the contract is made. If the clause is brought to the customer's attention after the contract has been formed, it will not be part of the agreement and cannot be relied upon. In this case, Paul paid for the hotel room and got the key at the reception desk. This is the moment when the contract was formed. No exclusion clause was mentioned or shown at the time of contracting. The first time Paul saw the clause was when he entered the room, after the contract was already concluded. This situation is directly governed by the leading case, Ollie and Marlborough Court Hotel, 1949. This table outlines the legal principles we walked through. In Scenario 1, based on Thompson and LMS Railway, a term can be incorporated into a contract if reasonable steps are taken to bring it to the customer's attention before or at the time of contracting. Even if the customer cannot understand the language, there is no duty to translate it. In Scenario 2, however, under Geyer and Kujawa, if the business is aware of the customer's language difficulty and refuses a request for clarification, it must take extra steps. Failure to do so prevents incorporation of the clause. In Scenario 3, following Ollie and Marlborough Court Hotel, an exclusion clause shown only after the contract has been made, such as a notice inside a hotel room, is not part of the agreement and cannot be enforced. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.